Welcome back. You're watching HFO-TV.
Welcome back to HFO-TV. I'm Greg Frick from HFO Investment Real Estate. Today we have Charlie Kovas, a partner at Warren Allen Attorneys. They are attorneys that specialize in landlord-tenant law. And we've got Charles here to talk a little bit about the changes in the marijuana laws in Oregon, how that may affect landlords and owners. And thank you for coming.
Thanks very much for having me.
Oh, you're welcome. Welcome. So maybe you can give a little update of where we've been and where we are today, and we kind of talk a little bit about the cause and effect of some of the changes in the Oregon laws in terms of the marijuana and how that's going to affect apartment owners and landlords.
Well, as you know, last summer marijuana became, let's say, no longer illegal under state law. It's still illegal under federal law. In October of last year, recreational sales began, and so now all of a sudden landlords have to deal with their tenants bringing marijuana home.
Right.
What do they do about it? Well, first thing, if the rental agreement says that tenants must obey all federal laws as a condition of their tenancy, then landlords don't have to allow marijuana because, again, it's still illegal under the Federal Controlled
Now, is that a
Substances
standard
Act.
clause that's in most, Multifamily Northwest, Oregon Rental Houses Association? Is that a standard clause in most rental agreements?
Yes, it is.
It is, okay.
Yes. Some landlords who draw up their own rental agreements will create their own separate marijuana addendum, but if you purchase one of the agreements that one of the companies has prepared, is generally going to include that language.
Okay.
So what can the landlord do about it if they don't have that language? If they don't have that language, they can serve a notice of termination for cause because the use of marijuana may interfere with the quiet enjoyment of other tenants.
Right.
That's a pretty good strategy. They could also do a no-cause notice of termination where in Portland, after 60 days, they can get possession of the premises back without stating a formal reason.
Right.
Ultimately, the important thing for landlords to remember is that now that marijuana is more prevalent, the rules have actually become a little more clear. It used to be that we were really concerned about discriminating against a medical marijuana user. Well, the federal government has made clear that there is no exception to the Controlled Substances Act for use of medical marijuana. So as a result, landlords can definitively say, no, I don't want to rent to a medical marijuana user.
And there's no discrimination protection on that because of the federal side, not so much the state side.
That's correct.
Right.
Now, that's not 100% definitive that you won't end up being sued, but it is clear that legal aid or one of the other tenant entities isn't going to pursue the case on behalf of the tenant because it is clearly against federal law.
Got it, okay. So it's the federal law protection that's giving you in terms instead of the state. But as you said, if the other option to go is don't do a no cause, go with a quiet and peaceful enjoyment. You're not really dealing with the quote marijuana issue. It's more what that effect is on the rest of the building.
That's exactly right.
Yep.
And I think the last thing to remember is that if it's a private market tenant, the landlord really has the discretion to allow it or not to allow it.
Right.
We've seen situations where the landlord has no problems with marijuana and maybe even joins in with the tenant.
Right.
That's okay under the law in Oregon if it's a pure market tenant.
I guess one question I would have in terms of that is does a landlord run into issues where he allows one tenant yes, one tenant no?
That is the situation where you would be concerned that one tenant is going to privately sue the landlord for selectively enforcing laws.
Got it.
And in that scenario, discriminating against this particular tenant, not because this particular tenant is a medical marijuana user or recreational marijuana user, but because the landlord's applying the laws differently against one tenant versus another.
So I'm sure your recommendation then for landlords is if you're going to have a policy, have it across the board.
Absolutely.
All tenants, do not make exceptions. That's where you end up running into trouble and things like that.
Yes.
Yeah.
One of the interesting things that we were talking about earlier before we started taping is something that really hasn't come up yet, but may come up. While smoking is generally prohibited by many landlord-tenant agreements and other building codes, what if in Oregon someone's just growing a plant in the unit? They're not necessarily violating the rights of somebody else, but they now have a marijuana plant that's against federal law. In that scenario, if there's no provision in the rental agreement preventing the tenant from having anything that violates federal law or preventing the tenant from having marijuana, the courts are going to have to figure out if that's allowed or if that's not allowed if we don't have the hook of going after
peaceful enjoyment
of other tenants.
And is it in terms of in the growing side of it with and is the idea that the federal side, is that going to be weakened when the state legalizes that, or does the tenant have maybe more of a leg to stand on if you don't have the federal? I mean, I guess that's my question. You can say it's illegal in the federal, so you can't break any federal laws. I mean, you still have the ability, the tenant can still point and say, wait a minute, it's legal in the state of Oregon.
That's a really astute question. Generally, landlord-tenant laws are creatures of state courts and not federal courts.
Right.
So if it's legal under state law and there's no separate contractual agreement that the parties have to abide by federal law, then the Oregon State Court may have no authority but to allow it.
Right, so that, and again, it's so early in the game, it has, yes.
The whole thing could go the other way. There's always a chance that a new president or a new Congress determines that marijuana is illegal under the Controlled Substances Act, and they turn back the clock on marijuana rules. Right now, under the Obama administration, they've allowed the states basically to experiment.
Right, do their own.
The reason they're allowing it is because the revenue production is so great.
Right.
My understanding, and I don't have the formal figures, but my understanding is that the state of Oregon anticipated about $10 million in tax revenue over the full first year, and they got over $3 million in tax revenue in the first month.
Wow.
And that's the only time frame that we have figures available for.
Right.
But it sure looks like it's going to be a real benefit to the general fund if there's not too big of a consequence to public health.
Gotcha. And then I guess another question we've had asked a little bit is the smoking and then the vapor. Is vaporing or vaporizing, is that considered smoking or not smoking in terms of use if you have a no smoking building?
Another great question. It's not technically considered smoking, but the Oregon legislature recently amended the Clean Air Act to include vaping. So because of that, we think landlords are going to be under pretty solid ground to state that the purpose of the no smoking prohibition is to protect, again, quiet enjoyment of other tenants, clean air. Clean air rules say that you can't smoke or vape within 10 feet of a doorway or a window, and you can't smoke within the premises because of clean air rules to prevent it from going up into the ventilation system.
Okay.
So we think landlords generally are going to be under safe ground if they say the no smoking clause applies to vaping.
Got it. And in your practice, are you having to represent landlords in this? Are they getting pushback in terms of tenants saying, hey, wait a minute, I've got a medical marijuana card? Or is it just so new that we really haven't seen that?
We've been seeing that pushback for years. Because the medical marijuana rules have been in place since I think 1998.
Right.
But the strategy really is even more clear now than it was before, because now that it's legal under state law, the federal government has had to clarify that it's not legal under federal law. So the intermediaries, the public housing assistance providers, HUD, the Fair Housing Council,
anybody gets federal money,
they've all had to come out and say, we're not going to pursue claims on behalf of tenants because it's against federal law.
Got it. So if that ever changes, then it's a whole nother...
That's right, but right now we think the rights have been clarified and landlords are under stronger ground than they were before. Because they can straight say, we don't want to take medical marijuana users. And previously that was a little bit gray.
Got it. Okay, so from the long, make sure you review your rental agreements. You know what's in there. Always. And it's probably a good idea to refresh those on a, annual or, once every couple of years, your rental agreements, making sure they're up to code and in terms of the new legislation and new things that are coming in. Because I know that's been an issue we've seen with some owners.
Always. Generally, if you have an impermissible provision in a rental agreement, that provision can be struck from the rental agreement, and if it causes a financial penalty, the tenant can seek twice the amount of that penalty from the landlord. So it's a really good idea to annually, or if not annually, every other year, make sure you have updated rental agreements.
Got it. And for people to get more information about you and your firm, where can they find that?
They can go online to warrenallen.com, or one of my partners, Jeff Bennett, maintains a website called OregonLandlordLaw.com, which will succinctly answer a lot of your questions.
Great. Well, thanks for coming again. Very informative, and we'll see you next time on HFO-TV.
Thanks for having me.
That was great. Thank you.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.